Okay, I think we'll kick off on that then. So we've got it's just after 2 o'clock. We've still got people joining, but that's fine. We'll just kick off now then. So first thing, hello, welcome to this Sulets webinar on the Renters Reform Bill, following the second reading of the bill recently in Parliament. My name's Irving Hill, and I head up Sulets. So who are Sulets? So hope you see this on the screen now. So we're an ethically led student lettings charity based in Leicester, which launched in 2012. We have a trustee board made up of the 2 student unions and members from the 2 universities. So we're in quite a unique situation. We are based on the De Montfort University campus, and obviously that gives us quite a healthy sort of advantage within the Leicester market. So Sulets is now the biggest student lettings operation in Leicester. We operate over about 2,300 beds, which is a mix between 7 large PBSA halls that we let for a large PBSA operator in the UK. And we've got around about 130 houses and other small buildings around the city, typical HMO stock. So we're going to be affected by this in much the same way as you guys are that are watching today. So why are we doing this webinar? Well, there's been a number of webinars on the bill so far, but none that we figured focused specifically on the student sector with analysis from a legal expert. So we thought it'd be helpful to put the webinar on today. We've got around about 280 people signed up, because it's a pretty popular topic, as you'd imagine, and we hope to be on for around about 30 to 45 minutes. One thing I would say is we've got people that have submitted questions in advance, so we've got some pre-submitted questions, and I've got those down to ask my colleague who's on this call with me. But please do fill questions out as you go along. So there's a Q&A button at the bottom. Feel free to add questions, add your name or not if you wish, and we will answer all or as many of these as we possibly can, depending on how many we get. So, okay, so enough from me, I think. So we're joined today by industry expert David Smith. He's a partner at JMW Solicitors, and David is the lead legal advisor for the NRLA, so that's the National Residential Landlords Association, and he's played an extensive role during the representations to DLUC, which is the department dealing with this, on the bill. So he's been in the room, so to speak, when these discussions have been taking place. So he's in a pretty good position to be able to give us some advice today. So next thing from me, so I'll say hi, David. How are you?
Hi, thanks very much.
Very good. Okay, so maybe if I hand over to you, and then my colleague can go through the slides with us, and I'll pose questions as they come along.
Great, marvelous, thank you. So it's probably worth saying that we're relatively up to the minute on this, and not only are we as per second reading, but of course, as you may have noticed, the King gave his first ever King's speech today. The main reason the second reading was pushed through was to allow this bill to cross over from one Parliament, although this is mostly transparent to people outside Parliament. Parliament effectively came to an end. The end of the parliamentary year has effectively occurred, and a new Parliament, although it's all the same people, starts from today for the King's speech and carries forward. Now that means that all previous parliamentary bills that hadn't already been passed are dead. But there is a process to cross those over, to prorogue them from one Parliament to the next. But you could only do that with bills that had their second reading. So the Renters Reform Bill basically had its second reading rushed through just before Parliament was prorogued and closed down 2 weeks ago, in order to allow it to continue to exist today. And continue to exist it does. It's been mentioned in the King's speech, and it sort of drives forward from there. In terms of how it works, it's also, I think, helpful for me to point out that a huge chunk of the Renters Reform Bill is simply modifying the Housing Act 88. Now, some bits of it are freestanding, but huge chunks of it only modify the Housing Act 88, which has an immediate corollary. And this will become clearer as I talk about all of this, but there are lots of things that just don't apply if your tenancy, for whatever reason, or your occupancy agreement, for whatever reason, falls outside the Housing Act 1988. So there are a number of contexts in which this will come clear as I talk along. But there are a number of situations where the Renters Reform Bill just has little application to people who are no doubt listening, because for whatever reason, their tenancy or occupation agreement does not sit within the terms of the Housing Act 88. And I'm going to elaborate on some of this. But obviously, just to give a quick sweep through all the sort of main items in the bill as it currently stands, is obviously getting rid of Section 21 notices, obviously been a bit of a big ticket item. The second point is that fixed term tenancies disappear as well. This is kind of a big deal for the student sector. All tenancies are effectively open-ended. There are a whole load of new grounds for possession. A lot of those are to do with social landlords because they use assured short-hold tenancies as well, which are all disappearing. Rents are to be monthly only. There's a much more structured mechanism for rent increases, which probably won't affect many student landlords. Then there's a whole load of additional stuff. You've got there are things about allowing pets. It's compulsory to have a written tenancy agreement. I'm hoping this doesn't affect many landlords because most do have one. There are new provisions about tenants giving notice. There are lots of new civil penalties because there are lots of new offences in this bill. There are landlord redress schemes. There is a PRS portal. There's a whole load of stuff about enforcement. And then there are three other things. There's a short let portal for short letting. That's not part of this bill. That's actually already come through Parliament. That's passed. It's in the Levelling Up and Regeneration Act, as it now is. And that will be heading forward quite quickly into the autumn. The Decent Home Standard was supposed to be coming to the private rented sector. As things currently stand, that is not in the bill. But we were assured at second reading that it would be in the bill, so we expect that to pop up quite soon. And then also banning marketing properties as no children or no DSS. That is not currently in the bill, despite it being promised. But again, at second reading, we were assured it would be in the bill, and we would expect that to show up at some point soon. But that's not the main thing that you want me to talk about. So if we could jump on to my next slide. The most important point is that there are no more Section 21 notices, and equally, there are no more ASTs. So all tenancies are effectively lifetime open-ended tenancies with grounds for possession linked to specific events. So specific actions or events, either in terms of the tenant not doing something or doing something, not paying the rent, or abusing the property, or other specific events. The landlord wants to get the property back to sell, that kind of thing. Trying to give a notice that is not within the limits of what is prescribed is an offence. Trying to grant a fixed term tenancy is an offence. And local authorities can either prosecute those offences in the magistrates' court, or they can offer civil penalties, and many will, I'm sure, in respect to these. And I suspect a great many landlords, because always for these situations when things change, landlords fall into two camps: those who are really switched on and know all about it, and those who sort of toot along in blissful ignorance. And I suspect a great many of those landlords will find themselves getting civil penalties because they have not appreciated that the world has shifted under their feet.
Can I cut in with something here, David? So going back to the Section 21, there's recently been a bit of a rowback on this, hasn't there? And the government said that they're going to keep Section 21 until the courts can basically keep up, I think. Is that essentially it?
Yeah, and that was re-mentioned in the King's Speech, but I really wouldn't get too excited about that. Bear in mind, the government has already said that there would be 6 months notice given before this came into effect for new tenancies and 12 months for existing tenancies. In the King's Speech today, in the briefing notes, the government said it's already thrown 1.2 million at digitising the court process, which was one of their 4 commitments. The other 3 commitments, I think it's arguable that they've already met them. I've certainly heard Ministry of Justice officials say they've met the other 3 commitments. So I don't really see it as altering the timeline, and the timeline for this bill appears to be getting it finished by early next year, looking to bring it into play, at least in part, by October next year. I don't see court efficiency as putting a substantial crimp in that from the government's perspective, because it will do those things in parallel as it goes through the enforcement process. Also, you know, without wanting to be too cynical, you wouldn't necessarily want to believe everything the government told you now, would you?
Far be it from me to make that statement. So there you are. Right. Okay.
Moving on.
Yeah.
So student landlords, obviously, loss of fixed terms is potentially quite complex for the student market. Student landlords, as a rule, rely on the fact that all of their occupiers will depart the property somewhere in or about summer, leaving them time to refurbish those properties and re-let them for September. And they are so reliant on this, in fact, that the vast majority of student landlords actually pre-let their properties in and or around January for occupation in September. So everyone knows where they stand. Now, the problem, of course, with all of this is if tenancies are open-ended and you can't be sure that that your students will leave, then agreeing to re-let it to a new group of students is pretty risky, because you'll have entered into a contract with them, and if you haven't got a property to give them, then you are potentially liable to them for losses and damages they incur in putting themselves into alternative accommodation, which is going to be pretty difficult to get their hands on because everything disappears pretty quickly in some areas. So there's a real challenge here within the student market. So the first thing the government has already said is that purpose-built student accommodation will be exempt. Now, in fact, the Housing Act 88 has a structural exemption already for student lets, where those lets are to full-time students and are carried out by entities that are members of the Unipol Code and who are also on a named list. And Sulets is one of the people on the named list, but then most of the other entrants on that named list are universities of one stamp or another. And the list changes fairly often and quite irritatingly from my perspective as a lawyer, to add or delete various new higher education and further education establishments that have joined or left the list, or even more irritatingly, changed their name and become just a slightly different, more coolly branded name, but still need to be on this list. So the government's proposal is to leave that provision in place, but to take the regulations that say who is exempt and rewrite them, so that I assume, and I do assume here, that all of the existing people on the list will still be on the list, but to have a more wider scope definition for your classical purpose-built student accommodation landlord. So private sector entities, essentially, that are dealing in purpose-built student accommodation. Now, the problem with this is we don't know how the definition will work. The government won't be telling anyone about it for quite some time. They will pass the legislation and it will be done in regulations separately. And there are a number of different ways it could be done. It's notable, for example, that for HMO property, there is a not dissimilar exemption for purpose-built student accommodation where the entity is a member of the Unipol Code, but that has left a number of universities in a difficult position where they were renting just houses off landlords and then subletting them back out, because the Unipol Code doesn't apply to single dwelling houses that have been rented and then sublet on. It only applies to larger properties, which I think off the top of my head accommodate 20 or more people. So there are some potential gaps in this. Obviously, that also leaves completely out in the cold the entirety of the PRS landlord group, who actually in practice provide, depending on which area you're in, 70% or more of all the student accommodation in specific student areas, depending on the market. It fluctuates up and down between 50 and 80+%.
Yep.
Now, the difficulty is that no similar exemption is going to be there for these people. So essentially, PBSA landlords will be exempt. They will be outside the Housing Act 1988 altogether. The Renters Reform Bill, therefore, will not apply to them, and they will be able to continue to offer fixed-term tenancies. Whereas PRS landlords will not have that exemption. They will still be inside the Housing Act 88, but they won't be offering what they currently offer, which is an assured short-hold tenancy for a fixed period of time, because they will not be allowed to offer that. They will be essentially offering fully assured tenancies and will then have to organise getting possession.
Okay. I mean, if I can jump in with a couple of questions here. I mean, this may seem like a daft question, but do you clearly this is still going through Parliament, and we don't know what amendments might be added. Do you think that, I mean, from your take, from what you've heard, do you think there's any chance that the government will row back on the idea of the end of fixed-term tenancies, or they're absolutely steadfast in that?
No,
I think even the NRLA have given up on that, haven't they?
They have. Everyone has given up on that. That's not going to happen.
Right.
But,
so
there is another offer on the table, which I will get to in just a second.
Okay. In that case, what I'll do is I'll cut in now one of my questions that's been submitted in advance. So it's quite handy you were mentioning university head lease schemes there in a way. So this question comes from Mike, who's a senior manager at a major university. So I'll leave it at that. So Mike says, as a university, our head lease scheme currently issues unregulated fixed-term tenancies. So no non-assured tenancies under paragraph 8, Schedule 1 of the Housing Act. Do we know if these non-assured tenancies will still be affected by the changes?
No, they won't be, because they fall outside the scope of the Housing Act 88, and the vast majority of the Renters Reform Bill only touches on tenancies within the Housing Act 88. Not all of it. There are bits of it that will affect those tenancies potentially, which I'll get to in a bit. But all the stuff about fixed terms in Section 21, no, won't affect that.
Right. Okay. Hopefully that's clear for you then, Mike. So if we move on.
So PRS student landlords are going to effectively have to deal with open-ended tenancies. Now, nothing about that's going to change, but in the second reading of the Renters Reform Bill, and again actually mentioned in the notes to the King's Speech today, what the government has said is they're going to create a new ground for possession for PRS student landlords. Now, the details on that are pretty limited, and a number of different versions have done the rounds. There was a slightly bizarre planned ground for possession that was usable at specific points in the year. I think that's probably going to go away, because it doesn't take into account that obviously different universities and different educational establishments start their years at very different times. And the way it was written, it was very much geared towards classical universities, without actually acknowledging that a significant number of people are in further education on a totally different basis. So I don't think it's a terribly useful way of dealing with it. But the reality is, what that means is that PRS student landlords will have open-ended tenancies, but they will be able to give notice on some basis, probably 2 months' notice, to inform student tenants that they will have to leave at a specific point. Now, there's a bit of a difficult position here. I mean, first, the offering to PRS student landlords is different from PBSA. PBSA are getting fixed-term tenancies. PRS student landlords are open tenancies with notice. The government takes the view that that actually is no worse than landlords already were, because the reality is, even if I offer a tenant a 12-month tenancy, they're perfectly entitled to remain in that property up until the point that I give them 2 months' notice under Section 21. Now, the reality is, and we all kind of know that that's not the reality. The reality is, if I offer someone a 12-month tenancy, the vast majority of tenants plan and organise themselves to leave at the end of 12 months, regardless of whether or not I serve notice. Yeah, and of course, most landlords never serve Section 21s. The tenant's just fixed to leave. The trouble is, of course, that's not a terribly good argument to make to government. It's not terribly helpful to go to government and say, well, we need fixed terms. Because even though people have all these rights, they don't really know that, so they just leave anyway. So as an argument, that was never going to be terribly successful before government. And so the government's position is that landlords are no worse off than they were. And technically speaking, they are right. But it does mean that PRS student landlords are going to have to give 2 months' notice. They are going to have to hope that the tenants comply with that 2 months' notice, which, to be fair, the vast majority will. But they're going to have to be organised about it. And it doesn't end there. That's actually not the most substantial problem from my point of, in my opinion. I mean, the reality is landlords were always in that position. The reality was, if you gave a tenant a 12-month AST or an 8-month AST, they could still sit in the property, and you would have had to give them 2 months' notice, and you would still have been running the risk that the property wouldn't be available for the next tenant. So I don't think the risk has changed dramatically for landlords in the PRS student sector on this front. Where things are a bit different, if we jump forward again, is tenants' notices. So because all tenancies in the PRS student sector are open-ended, tenants are entitled to give notice at any point. Now, the government has changed that to 2 months' notice instead of the current 1 month's notice, but it does essentially mean that tenants can give notice at any point and just walk out. Now, this poses significant problems in the student sector.
Yeah.
One, you can't be sure that your tenants won't just leave after 2 months so they don't like the property, or they don't like university and just drop out after a month or two, which happens to a significant number of students, potentially leaving you with a void property, which is very difficult to fill just after the financial year has started. Oh, sorry, the educational year has started. It also creates a problem with summer occupancies. So lots and lots of landlords, of course, sign tenancies that cover summer occupancy in order to defray council tax responsibility and also to ensure themselves of income. That's going to be very difficult. The reality is that students don't really want 12-month tenancies. They want shorter tenancies. They want to be able to leave and not pay for the summer. In addition to that, if the students do leave, of course, you will then be liable for council tax for that short summer period. If the local authority chooses to ask you for the money, and there won't be a lot you can do about that. And then finally, and this is the bigger problem, which the government has singularly failed to address, is that currently, if it's a fixed-term tenancy with, say, 4 students in the property, then if one of them decides they're leaving university, then they can't escape. They're still stuck with this property, and they remain liable for the rent unless they find someone to replace them, which is what usually happens. If all tenancies are open-ended and periodic, which is what they will be, then if one person gives notice, that is binding on everybody. And at that point, the landlord either throws everyone out and has a vacant property, or they effectively relet to those people who remain on whatever new terms they're agreeing. And that will obviously have knock-on effects in terms of rent recovery and property use. So there are real difficulties in terms of joint tenancies, which didn't matter too much in the wider private sector, but I think are particularly problematic in the student-led private sector, where you tend to get somewhat cobbled together sometimes groups of students who may have relatively weak ties to one another.
I mean, just jumping in at that point, I mean, would one solution be potentially to rent? I mean, I know this throws up other difficulties, but would it be to rent on a room-by-room basis, so that if X leaves from room 1, then the other people can continue? So almost like PBSA, that does obviously rent generally on a room-by-room basis rather than a collective agreement between 3, 4, 5, whatever people. Would that be one?
Yeah, and that's an obvious solution that I would expect many landlords will start adopting, and quite a lot of landlords have moved that way already. I think more will move that way. I mean, the other side point, of course, is that landlords are likely to enforce the 2 months' notice very strictly, and in some senses, it's quite unfair on students. For students in PBSA property, and of course, many students will often start in their first year in PBSA property, move out into the private sector, and then often move back in their final year or something like that. It's quite unfair because they'll be under different terms for different tenancies. And the reality is that, as I'm sure many of you are aware, students are not always the most adept at spotting their legal responsibilities and not really necessarily up to speed with that. And advice for them is patchy. In some places, it's very good. In some places, it's pretty poor. And students will sit there in year 1 thinking, absorbing that they didn't have to give notice and they just had to pay up until X date and then they were done. In year 2, they might move out to the PRS and not appreciate that they have to give 2 months' notice, at which point PRS landlords will be saying, well, sorry, but you haven't given me notice. You're still liable for the rent up until you give me the 2 months' notice. Thank you very much. And that also, of course, has knock-on problems in relation to deposits, which are, of course, capped at 5 weeks and therefore are less than 2 months. And if that deposit money is burned up in rent arrears caused by lack of proper notice, then you're involved in all kinds of attempts to recover relatively small amounts of money from people who are quite difficult to recover money from. So there's a whole sort of host of slightly weird knock-on issues around tenant notice that I think in practice are actually more complicated and problematic than for people who are than for people who than the sort of whole tenancy length thing. The fixed term thing is less of an issue than tenant notice.
Okay, I'm going to jump in with a few questions here that I've got that have been given to me in advance. So one of them is Vinay has asked, I think we've already answered this actually, but still, Vinay's asked, could students still give notice in May after exams leaving a summer void? What is the impact to student landlords? What is the concession for student landlords? So I think, well, essentially, yes, they can is the answer, isn't it, right?
Yeah, yes, they can. The impact on you is you're going to have to deal with summer void. So summer void periods are going to be a major problem for student landlords. And I think trying to find ways to mitigate that problem for many student landlords will be the key factor. For some student landlords, it may not be an issue. They might be in an area that also lends itself to short-term holiday letting. For other student landlords, it's going to be quite a serious problem because there'll be an area that does not lend itself to short-term holiday letting.
Sure. Similar vein, so Simon has asked, why does the bill introduce asymmetrical rights for tenants and landlords, e.g. notice periods? What can be done to mitigate this?
Well, I think the government's position would be that it was already asymmetrical and they're symmetricing it up. I'm not going to comment on the relative rights of landlords and tenants, I'm afraid. I don't think there's anything useful I can say on this. I mean, it is within the government's prerogative to alter the balance of power. That is what they have done.
Yeah. And then again, similar thing. So Paul has asked, how are the government going to reconcile flexible tenancies with student term times? What about students who are in the PRS and maybe hybrid learning? How do they fit into this?
Yeah, I mean,
I think it's essentially the same thing, isn't it? They can give notice in March to say, okay, well, we want to be out by May, which would be a typical time when most of the lessons would have stopped, and that will be that, won't it?
I mean, the reality is that the government's not going to reconcile it because they don't really understand what they're talking about.
Right. Not great. Not the best news then. So okay, so if we roll on then, I think to slide 9 then.
Right, so options. Well, one option, I think, potentially, depending on how the government chooses to write its regulations, is that, and this has already been an option out there, is people will let to an approved PBSA provider who will sublet. Obviously, that will have an effect potentially limiting income to landlords, but it takes away the whole problem and they can just sit back and treat it as a more passive income source.
Yeah.
You could accept the new system. That's not necessarily the most. I don't know why I put this option in. It's not an option that many people are going to on this webinar are going to like.
Yeah.
But the reality is you bear the brunt of the new system. Probably take the view that in practice tenancy length is less of an issue and find ways to mitigate the summer void issue. And I noticed someone on the Q&A suggesting that many landlords would simply start tenancies earlier. Yeah, that's an obvious possibility. Another option would be to look at licenses. Many PBSA providers don't actually rent on tenancies at all. What they do is they provide in-room cleaning and use licenses, and they have done for a long time. Student university halls are almost all let on that basis, in fact. So one option for landlords is to stop being landlords and become licensors, provide in-property services, and cleaning being the most obvious one, which also means that your properties will be cleaner, which is saves you perhaps the massive deep clean that many student landlords have to engage in at some point in the summer, and then operate as a license. Because it's a license, it won't be a tenancy. It will fall outside the Housing Act 88. The Renters Reform Bill will not apply. Fixed term licenses are back, easily resolved. Another option particularly for people who are letting to overseas students who tend to want to pay all of their rent in advance, would be to look at what is called, or used to be called, a premium lease. These were quite common in the London market, but have gone away because they were very tax efficient. They no longer are. But effectively, it's exactly the same as a leasehold flat. So you pay a premium in advance for the grant of the lease, and then the rent is a trivial amount of money, like a peppercorn, or £1 a month or £1 a year, and that sits below the minimum rent threshold of the Housing Act 88, which is several £100s. So it sits below that, and it falls outside the Housing Act 88 for another reason. For example, most people think that long leases of flats are outside the Housing Act 88 because they're long. They're not. They're actually outside the Housing Act 88 because the rents are too low. And so the same thing can be applied in student lets, but it does rely on you really taking all of your rent in advance for the whole term of the tenancy. So it's likely to be more attractive to people who have got large numbers of overseas students who are often in a position to pay all of that rent up front for a specific time.
That's going to be quite difficult, I suspect, for people that are generally catering to UK students, because
sure,
you know, most of the UK students that we see wouldn't be in that position, and I mean, certainly wouldn't be our approach to do it, but they wouldn't be in that position anyway. Maybe if I can ask you a couple of other questions. So first one is, I suspect the licensing thing would be quite interesting to a lot of people. So that's going to be a fairly complicated area of law, isn't it? I suppose you're not just going to be able to say, cross out the word tenancy at the top of your document and say license, and say, here you go then. So this
to be fair, a lot of people do that, but that would be a mistake. Yes, an awful lot of people do cross out, do global replace and replace landlord with licensor and tenant with licensee. That's a mistake. That doesn't work, but it can be effective. And also, as an aside, it takes away things like tenancy deposit protection. So one of the ironies of this, and one of the really unsatisfying aspects of the Renters Reform Bill, is in some markets you may find occupiers left with less rights than they had before. In that you'll go back to sort of the bad old days in a sense of students, you know, not only not being tenants, but also potentially not even getting what we now consider to be the basic protections of tenancy deposit protection, and their deposits essentially being taken at the end of every tenancy with little practical recourse.
Yeah, I mean, earlier on you said, linking back to a previous slide, you said there'll be penalties for landlords trying to grant anything other than new tenancies that we're discussing here. So I suppose that's another problem, isn't it? So if somebody did try and issue a license, is there a possibility that they turn around and say, well, this isn't actually a license, my friend, and here's your fixed penalty notice? Do you see that happening?
Yeah, sure. I mean, local authorities are a bit problematic here because they don't really, many of them don't understand the tenancy license distinction. And yeah, sure, making a mistake and getting your license wrong is a really good way to end up with a penalty for having issued a fixed term tenancy in breach of the legislation, for sure.
Yeah, sure. Okay, I've got another submitted question. I mean, to be honest, I think we've covered it, but somebody posted in advance, so I'll ask. So Matthew's asked, how do you see responsible student landlords working around the likely restrictions imposed by the Renters Reform Bill to maintain their business, services and incomes? What lessons can we learn from the experience of Scottish landlords? Obviously, because they've had something similar, haven't they? So presumably the licensing thing is one angle, isn't it? I'm guessing.
Well, licenses and leases don't work the same way in Scotland. It's quite hard to create a license in Scotland, so no, that's not really an option. In Scotland, I mean, the main thing we saw in the student sector is that student landlords stopped being student landlords, frankly. And the reality is that the holiday let market in huge chunks of Scotland is far more substantial. You know, if you're in Edinburgh or even Glasgow, for example, switching your property from student letting to Airbnb, other platforms are available, of course, is not a terribly difficult task. And the reality is that the availability of student let PRS property has gone through the floor in Scotland, and it's been a terrible mistake. And I think certainly I've somewhat somewhat casually chucked quit on there as an option for student landlords, but I don't doubt for a minute that there will be student landlords in specific student areas, which are also, I mean, Oxford, for example, places, or London, places that have high numbers of tourists for significant parts of the year, who may in fact think actually there are far better options than continuing to rent within the student sector with these additional burdens.
Yeah, I mean, the irony is you're just going to end up with less accommodation, aren't you? Really, which is what has happened in Scotland, isn't it?
Yeah, I mean, there's been a shortage of accommodation, certainly in the student sector. It's become more expensive in the other parts of the sector, but that's for slightly different reasons. But I'm sure some student landlords will move back to single family lets, and some student landlords will move into other types of letting. I'm quite sure of that.
Okay.
I think the other option I mentioned, which we've already sort of canvassed, is the issue of room lets, and clearly for many student landlords now, I think moving towards a room let model rather than a house let model is likely to be a way they will go. And again, I don't see that as necessarily a progressive position from students' perspectives. I mean, there was a benefit, I think, a social benefit to students having to form house groups and work together, which room lets to some extent erode. It's a somewhat nebulous social benefit for sure, but I think it probably did have a social benefit. And I'm sure many people listening to this webinar would recall that period of their life with a mixture of affection and horror, but certainly as a learning experience all the way down the road.
Okay. Okay. If we maybe move on.
So
I think some of this we've already covered, haven't we?
Yeah, I'll just run through it quickly. But I'm going to say, so licenses are outside of Housing Act 88. They're not affected by the Renters Reform Bill. They are more difficult to do, and you must offer in-room services, and the most obvious one is cleaning. They are viewed very much with suspicion by courts and local authorities, so you do need to be very sure that you can prove it. And then I've also said room letting is a rational response to tenants giving notice. It gives landlords control over occupiers in a much, much tighter way.
Yeah.
And if we move on from there, possession. I think whatever the government says about court reform, I think the courts are going to get slower. The difficulty with all of this is tenants are also much more likely to defend cases. Tenants don't tend to defend Section 21 possession actions at the moment, but if I've got to give a reason for every single possession action, a great many Section 21 possession actions are for low level of rent arrears, or poor payment histories, or antisocial behaviour. Tenants are going to be much more likely to defend those slights on their character and say, well, no, I didn't pay the rent, but for reasons, or I wasn't antisocial. And so I don't think the courts will cope with that extra load. They will also inevitably be more expensive. Solicitors will charge more because the cases will be more complex and people will have less choice. DIY options like accelerated possession proceedings will go away, and rent arrears will go up. And as a corollary of all of this, all the notices involved are more complicated. Section 21 notices are relatively simple things. Notices where you're giving reasons for possession are more complex. Notice periods are all different. They're all being changed under the Renters Reform Bill. So there's going to be a lot more pressure on getting things right and on good compliance.
Sure.
In relation to that, I mean, for rent arrears possession, notice periods are now doubled. So instead of there being 2 weeks notice, there'll be 4 weeks notice. The grounds possession, ground 8 for 2 months arrears, ground 10 for some rent arrears, ground 11 are the same apart from that. But then there is a new ground 8A for repeated rent arrears, where you've gone into 2 months arrears 3 times in a 3-year period. But for many student lets, I don't see that as being a particularly interesting ground for possession.
Right.
Moving on, there is a new ground. If you're planning to give up and sell up, there will be a new ground 1A, where a landlord wishes to repossess a property to sell, which you cannot use within the first 6 months of the occupation. And you can't use it if the tenancy was assured by succession, but I don't think that'll be relevant to most people here. And it creates a 2-month notice period. Obviously, one of the concerns about this is people lying about it. There's a lot of fuss from tenant groups saying landlords are just going to lie. I've certainly seen a few landlord forum posts where landlords say they will lie. The government has said it will. Its comments on that will be made clear in as the bill moves forward into the Bills Committee. I should point out that this is not the great panacea. Lying about selling in court is contempt. And for this type of contempt offence, the starting point is 3 months in jail.
Mm.
So if you are found guilty of it, which is not terribly difficult to do, the starting point for a judge is not whether or not to send you to prison, it's how much time to send you to prison for. So the consequences of telling lies are quite serious.
Not a great idea then, basically.
I don't recommend it to people.
No, and I don't want to be. Yeah.
So let's just push on to talk about the last few things that I want to talk about.
Yeah.
So rents will be monthly or 28 days only. If you do it as anything else, it gets recalculated and you can be penalised. It is unclear how we deal with payment in advance. There was some suggestions that originally that you couldn't then take 6 months rent in advance or a termly rent. The government says it thinks that you can. So rents will still be, what you would say is the rent is £500 a month, but payable 3 monthly in advance in the sum of £1,500, which is commonly done now. The government seems to suggest that is still permissible. So I don't see this as being a particularly interesting provision in the end, because most people in the student sector will simply say, well, the rent's £500 a month, but payable 3 monthly, 6 monthly, whatever, in advance, to cover whatever payment periods suit them.
So just to cut in, so it might not be quite as painful as it first looks, because obviously for most student landlords, lettings agents, what have you, they'll be, their payment terms normally aren't monthly. They mirror the sort of student term, so they'll either take, maybe a payment up front initially, and then 3 more that will mirror the student term. But you don't think it's going to be quite as painful as the idea of them to take this every month for 12 months then, or what have you?
No, I don't think. I mean, that's what I originally thought. How I interpret the legislation, DLUHC has informed me that my interpretation is wrong, and that is not what they intend. And I get the impression that they will amend the legislation to make that slightly clearer.
Sure.
So let's talk about rent increases. Again, I don't think many student landlords will be fussed by this, but rent increases will only be able to be done by way of a statutory rent increase notice under Section 13. So rent increase clauses in tenancy agreements or agreed rent increases will be of no effect. And everything will have to go through the tribunal. There's also a longer notice period, so 2 months notice before you take it to the tribunal. So in effect, I think this is kind of a form of rent control, because what it will do is it will effectively delay every rent increase for at least 2 months while your notice takes effect, and also for such longer time potentially as the tribunal takes to deal with the matter. And at the moment, the first tier tribunal is taking around 8 months to deal with rent increases, so it can take quite some time for those rent increases to kick through. But for most landlords, this is not really relevant in the student sector, because most student tenancies are an annual basis.
Yeah,
it will affect landlords potentially who are letting more to postgrad students for potentially longer term.
Okay.
Shall we move on?
Yeah.
So, as already said, all tenants must provide written terms of their tenancy. And the regulation, this is all to be done in regulation, so no one really knows what it says, but you can either say it'll either require specific terms about specific things, information about the tenancy, or specific wording about rights. I would anticipate that things like the How to Rent guide are going to get sucked into the body of your tenancies. And I suspect that it's going to look a bit like things are in Wales for people who are familiar with Wales. Obviously, agents get potentially a lot out of this because it creates a marketing drive for them.
Yeah.
But it also means that I suspect most tenancy agreements are going to be a great deal longer and more complicated. Certainly at the second reading of the Renters Reform Bill, Michael Gove actually piped up and said that the regulations would include a clear set of statements around antisocial behaviour for which tenants could be evicted, and with examples. So I suspect more words are the upshot of all of this. Again, if you don't provide written terms or they don't meet the standard, then prosecution is an outcome, or again, civil penalty from a local authority. Yeah. Pushing on. Landlord redress schemes. This is outside the scope of the Housing Act 88. All landlords will be required to join a landlord redress scheme. I would imagine this will include PBSA landlords. And it will allow for complaints from prospective tenants, current tenants, or former tenants. And you must have joined before you can market your property. So you must get this all in place before you start marketing. Now, it is a concern as to the government getting all this in place. Schemes can charge fees. So currently only agents have to join redress schemes. Landlords will have to join as well. That will effectively mean 2 memberships for many landlords, one via their agent and one for themselves. No one is clear who the schemes will be. Again, at the second reading of the Renters Reform Bill, there was quite a lot of discussion, which Michael Gove certainly agreed with, about reducing all of this down to having 1 ombudsman. Currently, there are 2 for agents, but the suggestion is that it might all be concatenated to a single ombudsman. Again, not having this, you can be prosecuted or civil penaltied, and given that you have to have it before marketing and be clear that you have it on your marketing, it'll be quite easy to catch people. Moving on. Separate to that, there is also a PRS database, which is basically a landlord register. So not only do you have to pay as a landlord to join a redress scheme, you must also pay a separate fee to join a portal or the portal. That works as a number basis. So landlords will all have numbers. All of your properties will also have numbers, and your marketing will have to include those numbers. You cannot market without those numbers because they must go in your advertising.
If I could just cut in at that point, what will happen for landlords that use an agent? Is that likely to be different or not?
No, everyone will have to join. It is possible that landlords who have an agent, the agent will be able to sign them up, but all landlords will have to join the portal.
Okay. I suppose that there's maybe, is there some hope that this will see, I don't know, maybe I'm wrong here, that this will curtail some of these selective licensing schemes that are developing all around the UK. There's
Not
a bit of an
so
overlap,
far.
isn't there?
I mean, the current government's position is that it's likely to curtail blanket schemes and keep them more targeted. It's certainly worth noting that in Wales, every Welsh authority had a blanket selective licensing scheme at the time Rent Smart Wales came into effect, and now nobody in Wales has any form of selective licensing. Sure. So I think there's certainly a possibility that some schemes will start to be curtailed because it won't be worth running them.
Right.
Again, if you don't do it, civil penalties. So timing. Someone I noticed did ask, is this really, am I serious that this could all happen next spring? Yeah, absolutely. The second reading was squeezed in before prorogation. The second reading also included a timetable for the bill, which had everything finished by December the 5th. And basically it being done before Christmas. So
yeah, just to interrupt. I mean, I suppose given that this Parliament hasn't really got too much longer to go anyway. I think it's January 25 at the most, isn't it? If they hung on to the grim end, they've really got to get this done quickly. Otherwise, it's just going to fall before the general elections call them, isn't it? Really.
Yeah, and that's why I say giving it a push. I see government pressing very hard to get this completely done with royal assent by spring. With the objective then of giving 6-month warning period for implementation and coming into effect in October at about the same time as they go to the country. So that they're able to turn around and say to people, look what we did. So yeah, I think the government is absolutely set on a fairly helter-skelter timetable, and the timetable they put forward at second reading was nothing short of helter-skelter, and broadly had huge chunks of this done by Christmas, and I think they will stick to it. Right.
Oh, So just the final slide, and then let's crack on with the Q&As. We've got quite a few that have come up, so maybe if I have a look at some of these. So first one up is, will we access to these slides? So presumably, are we going to send the slides out? So yeah, nice easy answer to that. So what we will do after this, after the webinar is finished tomorrow, we'll send out an email with a link where we will upload this webinar, and you can watch it to your little heart's content. So yes, the slides will be there. So I've answered that one. Okay, how will the rent be increased on an assured tenancy? I think we've answered that, would you say?
Yeah, I mean, it will have to be done by Section 13 notice. I'm also typing a few rapid answers to some of the quick questions.
Okay. Next one up, we've got what makes you think it will go through Parliament so quickly? So yeah, I think that one's been answered as well. Next one up we've got is what is the ground of the 2 months notice they give? I'm not too sure what that means. What is the grounds of the 2 months notice that they give?
Oh, what ground? Well, if you're talking about landlords notices, then I don't know what the ground number will be yet until the government lays the relevant amendments. If it's for students, then it won't have a ground as such.
Right. Okay. We've got one from Ellen White. So you've indicated that you were going to answer this. So yeah, do you anticipate the exemptions will be made for PRS student landlords as well?
I think I've kind of answered that, and that I think there'll be a ground for possession. Yes.
Yeah. Can PBSA serve a notice like PRS just to be safe?
Yeah, if you want to. I don't see why not. I'm a lawyer, so safety. Yeah, why not? I'm all for that.
Okay. Adam has asked, where sharers are concerned, if one serves notice but the other sharers do not agree with the person's notice, where does that leave the landlord? I think that's it.
Well, in a very difficult position is the short answer. I mean, the reality is you will either throw all of them out, or alternatively, you will have to come to effectively a new arrangement with those sharers, either implicitly because you just didn't do anything about it, or explicitly in that you sign a new agreement.
Yeah, and we've got another one that's on a similar vein. So if one tenant leaves a joint tenancy but the others remain, does the tenant not continue, or the tenancy presumably not continue, because all tenants did not vacate? That's just not the case, does it?
Well, it kind of depends on the circumstances, and that's one argument, but it kind of depends on what the landlord elects to do in the relationship that pertains. If the landlord just keeps taking rent from the remaining tenants, or adjusts the rent for the remaining tenants, then quite clearly he's let that tenant go. So no, the short answer is it doesn't quite work like that.
Okay. Deb has asked, could it be an issue if students change their minds on taking a property a short notice period to moving in?
Yeah, short period after moving in. And yes, I think that will happen in lots of cases. I think many landlords will very annoyingly find themselves entering into tenancies and have the students arrive, decide they don't like it, see that there's another property available, and give notice and leave.
Okay, Michael has asked, will these changes mean that PRS landlords will have to wait to advertise and sell their properties 2 months prior to their availability?
Yes, possibly. I mean, to be honest, I don't really see it as hugely different from now, because the reality is that even under the current regime, students could just not leave at the end of the fixed term. So I think the risks are more acute, but they're not dissimilar to where they were.
Sure. Okay. Robin has asked, and I think you've already answered this one actually, to deal with summer voids, landlords will start contracts earlier, i.e. June, August instead of September. I mean, I think that's possible, isn't it?
Yeah, and I think I mentioned that. It was Robin's comment that I mentioned when I was talking about it, because I thought it was a good point.
Yeah. And he's asked another one, is the big concern that the uncertainty and risk posed here will drive PRS landlords out of the sector? I mean, yeah, I think it is. With demand outstripping supply in many locations already, what impact will this have on rents, where undersupplied locations typically
See,
have the highest rent.
I don't entirely agree with all landlord groups on this, which is probably going to be surprising. I don't entirely agree with the government. The government says it won't make any difference. I do think it will make a difference in that more landlords will leave the sector, but the question is, will they not simply just sell to other landlords, in which case it won't make much difference? Or will they sell to other people, in which case, yes, it will. I mean, these aren't really the issues. The issue is that there's simply too few properties available for the level of demand for those properties.
Okay. Well, we're sort of rapidly running out of time. We've gone over quite considerably, but it's good because we've got a lot of questions. I'm going to whiz through a couple of these. So these two are the same, essentially. Ruth says, could you please expand on the license model? Anonymous says, how do you obtain a license? I mean, that's a bit too complicated to answer on here, I guess, doesn't it? It needs a lawyer, doesn't it, really?
The short answer is you need to speak to an appropriate lawyer who can help you.
Yeah. There you are. Okay, Valerie says there will be a transitional period. Is it the timing on when the legislation is enacted here? Will it be a transitional period where the students are timing-wise in the academic year? I'm not a bit lost on this one. Can you see this one? Can you help with this, David? Do you think the government will be mindful of the academic year challenges for the PRS?
Do I think the government will be mindful of the academic year challenges for the PRS? No, I don't think the government will have any consideration for it at all, but I don't think it will matter, because the way that they will probably the legislation intends that it will be set up is that things just won't kick in for existing tenancies, and they'll only kick in as tenancies recirculate in practice for most people.
Sure. Okay. Let's deal with some quick ones there. Well, this isn't that quick, actually. Is there a definition of PBSA?
There will be, but not right now.
Right. PBSA means purpose-built student accommodation. Somebody's answered, so that's good. Thank you. Dare I ask, when do we think the decent home standard will be introduced?
Well, that's quite an interesting one. The decent home standard is being rewritten at the moment. The plan is to simply stick it into the bill and then introduce it in regulations, probably sometime in October next year. Sure.
Okay. Anonymous has said, in some areas where Article 4 exists, if the property becomes less than 3 people, it no longer qualifies as being able to be let as a HMO. Renting on a room-by-room basis could potentially result in landlords losing Article 4 if not all rooms are let.
Yeah, I don't think I can answer that question, because I think it contains several fairly fundamental misunderstandings that are hard to address.
Okay. If there is more than one landlord to a property, will each landlord be required to sign a database? Presumably so.
Yeah, absolutely. And a side problem with that is that some landlords have multiple properties in different entities. And one of the things we've found in Wales is that landlords make mistakes. They'll register themselves while failing to appreciate that they might own another property with themselves and a spouse and a third property through a limited company.
Yeah. Anonymous has said, you mentioned landlords will have to give students 2 months notice. What is the grounds of this notice? Don't they have to give a specific reason? I mean, that's being worked through at the moment, isn't it?
Yeah, I mean, there will be a ground, but I don't know what that will be and how it will work.
Right. Okay. So that's to be decided as it's going through Parliament, isn't it? Really, that's.
Yeah.
Okay. And last 2 questions now. So if
I've come to one by answering one quickly.
Okay. Landlords will just increase rents to match the same annual income amount received now, so as not to lose income and protect against summer voids. I mean, I think
yes, quite possibly. Right, I wouldn't be at all surprised to find the rents go up.
I think that might be right. Okay. Right. Okay. So we've kept a substantial number of you to the end. So that's great. Thank you for attending today. We'll do a follow-up on this. So once the bill has actually gone through Parliament and it's a bit closer towards royal assent, and we know exactly what the bill is going to say, because it'll be getting itself turned into an act, we will do a follow-up on this. So we hope to see some more of you back on here again. Dave, if you can potentially put the contact me slide up for us, that'd be handy, please, so that people can see how they can get hold of me and David if they want to. Other than that, thanks for joining, and enjoy the rest of your day. Take care. Bye-bye.
Thank you.